Hello. My name is Crystal Dahl. I'm the Online Communications Specialist here at Meritas. For those of you who don't know, Meritas is an established global alliance of independent law firms. Our firms can be found across 81 countries and 234 global markets. We have 106 law firms worldwide and over 7,100 lawyers. I would like to thank and welcome each of you for joining us on today's presentation. Before we get started, I'd like to quickly go over a few housekeeping. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into an associated telephone line instead. Just send me a chat message and I can send you that phone number. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect. Since you will be muted, if you have any questions, please ask via the chat feature. It's found on the left-hand side of your screen. We are planning to answer most questions throughout the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of this webinar, as well as each of the presenters. Today's webinar is also being presented live at Boughton Law Corporation, our Meritas affiliate in Vancouver. I'm going to turn it over to Matt, the marketing specialist. Matt, are you ready to get started?
Yes, I am.
Okay, continue?
Yeah, continue, please.
All right, and so, as I said, if there are matters you wish to pursue in more detail, you have our contact information. Please do not hesitate to contact us. We will assist you. Point number 2, this topic is very relevant. I'm going to refer initially to the Globe and Mail article of March 27th of this year. And this article refers to the IT industry, but it has a more universal application across various sectors of the economy. And I'm not going to read the entire article, I'm just going to quote from it. Okay. So this article basically says that, written by Sean Silcoff of Globe and Mail, March 27, 2016. After winning a big concession in the budget on taxing stock options, Canada's tech startup sector is braced for its next battle, urging Ottawa to fix immigration rules that limit its ability to hire top foreign talent. Under policy changes enacted by the Conservatives, employers must now validate a job offer by getting government approval for a labor market impact assessment, showing it couldn't find Canadians to do the job. While that approach targeted abusers of the Temporary Foreign Worker Program, it meant fast-growing tech firms searching for the best employees globally had to submit to the same drawn-out process, only to be told in many cases by Ottawa that they should just hire a Canadian. The article further states that tech startup leaders say the rules not only add delays, but that the process lacks transparency and consistency, imposes needless bureaucracy, and lacks an appeals process. In many cases, would-be recruits choose other offers rather than waiting. Foreign students awaiting government approval for their job offers sometimes must leave Canada when their study visas expire. 6 out of 10 employees surveyed by the Canadian Employee Relocation Council last year said that immigration changes under the Tories had hindered their strategy planning and recruiting. 1 out of 6 opted to create the jobs abroad instead. Then the article at the very end quotes Stephen Crine, who's the Chief Executive Officer of the Canadian Employee Relocation Council. And Crine says that the government could address many concerns with simple, non-legislative changes, including creating a trusted employer program to let employees speed up applications and relaxing the need for LMIA. He says that would improve things significantly for business. So while the article does say that the government is going to review the LMIA program, for now, employers have to deal with the LMIA process unless they can work around it, which is the focus of this particular seminar. All right, so in terms of, we'll just go back to the previous slide for a moment. In terms of our agenda, dividing it into four parts: the basic principles and terminology, the LMIA and employer compliance review, the impact of NAFTA, gaps in the Canada-European Trade Agreement, and then in part 4, DJ will take on more detail about that Canada-European Trade Agreement, which is imminent. So, the BC Labour Market Outlook for 2014 to 2024, published by Work BC. More than 935,000 openings are expected in British Columbia in the next decade. Labor supply and demand are expected to grow at approximately 1.2% per year for the next 10 years. 75% of jobs will require a post-secondary education, either college or trade training or a university degree. And by 2024, 68% of job openings will come from replacement demand due to retirement and death. Next slide, please. So how are these jobs going to be filled? Well, if the available domestic supply falls below the demand, employers are going to look at the availability of foreign workers. And the admissibility of those foreign workers is the responsibility of the federal government. And the policy approach of the federal government, when it issued the revamped temporary foreign worker program in July 2014, is set out at page 10 of that document, and it basically says that the admission of temporary foreign workers is a last and limited resort to allow employers to bring in foreign workers to Canada on a temporary basis. So my first point is that there's a bit of a fundamental conflict between what the government of British Columbia envisions is going to happen over the next decade in terms of the need for workers to supplement the domestic supply of labor, and the federal government, who is basically taking the stand that importing foreign workers is a last and temporary measure. And we're going to see how realistic that is over the next decade. So in terms of context, I wanted to speak about the immigration system briefly to put this whole issue of where foreign workers fit into the context of Canadian immigration. So first of all, under Canadian immigration law, Canadian citizens and every person registered as an Indian under the Indian Act have an absolute right of entry. All right? So as long as you can demonstrate at a port of entry that you are a Canadian citizen, you must be admitted. Permanent residents of Canada have a qualified right of entry, and they can lose their permanent resident status for convictions, for matters of serious criminality, for being determined to have entered Canada fraudulently, for making material misrepresentations as to their ability to be admitted to Canada. But most commonly, permanent residents lose their permanent resident status by failing to meet the basic test of 730 days of physical residence in a 5-year period. So when you're an employer and you have permanent resident employees who you intend to transfer outside of Canada, Section 28 of the Immigration Act does exempt permanent residents from that 730-day in 5-year period test if they're assigned to work abroad by Canadian business. But be careful, because that particular exemption has been litigated at some length, and the Immigration Appeal Division, which hears these appeals, and the federal court at times, have put some very significant restrictions on your ability to move permanent residents abroad and ensure that they keep their permanent resident status. So foreign workers are basically a subset of temporary residents. And so you have citizens, you have permanent residents, and you have temporary residents. And so generally speaking, all temporary residents must report to a Canadian port of entry on arrival. They must be entering for a temporary purpose as a worker, a student, or a visitor. They must demonstrate they will leave Canada at the end of their stay. And in certain instances, temporary resident visas are required by a significant number of foreign nationals, depending on their country. And the most before I'll just say one more thing. There is a specific list of countries exempt from the TRV requirement under Regulation 190, but it's subject to change at the discretion of the federal government. And you may or may not remember that in July 2009, the federal government imposed a temporary resident visa restriction on the Mexican nationals. That has been an ongoing source of tension between Canada and Mexico, and the new government announced that they were going to relieve Mexican nationals of that necessity to obtain a temporary resident visa before they approach the port of entry. That came out in March of 2016, but as of this morning, I looked, and until further notice, Mexican nationals still need a visa to get into Canada. And what that means is that they must apply at the Canadian Embassy or High Commission or a consulate to obtain that visa before they approach a port of entry. Now, there's also one other new wrinkle to the admission of temporary foreign nationals into Canada on a temporary basis. There is a new item called an electronic travel authorization, and it's not on the slide, but this is a new entry requirement. It is for visa-exempt foreign nationals from specific countries who fly into Canada or transit through Canada. They must have this electronic travel authorization. It costs $7. You apply electronically. It's valid for 5 years, and in most instances, it is available very, very quickly. U.S. nationals and persons with Canadian visas are exempt from that process. Moreover, there's a delay in implementation, although theoretically you are to get that ETA if your country, you are on the list of countries whose nationals must obtain an ETA, but until September 29th of 2016, it's not mandatory. But after the 29th of September 2016, it is going to be mandatory. Now, go to the next slide, please. One other conception that I want to address is this issue of permits versus temporary resident visas. There is a difference in Canadian law between a permit and a visa. Very often, the common parlance is, I need a visa. Well, yes, you may need a visa, but it's more than just a visa in our situation. Permits allow persons to visit, work, or study in Canada. And permits are normally now issued electronically at a port of entry. But a visa, which used to be a stamp impression placed into your passport, is now scanned into your passport and by a visa officer at a Canadian consulate, High Commission, or embassy. And that is the only place you will obtain a visa. You may have it renewed from within Canada, but the initial visa you must obtain from outside Canada. And if you have no TRV when you approach your port of entry and you're from a country that demands it, even if you're holding on to a valid work permit, unless you're entering Canada from contiguous territory, which is basically the United States or the two French islands of Saint-Pierre and Miquelon in the St. Lawrence, you'll be denied entry. And where this has happened and where we've seen it happen is when a person was issued, for example, a national of India was issued a single entry visa, and he had a long-term work permit. And he chose to go home for a visit in the course of his period of employment in Canada, and he did not renew his visa overseas. He just got back on a plane. He landed at Vancouver Airport, and even though he had a valid work permit, he was denied entry. And he fortunately had a U.S. visa, and he was able to enter the United States and wait until we were able to file and obtain the necessary visa for him. Some of that type of problem has been mitigated by the federal government permitting applicants who are in Canada on work permits or study permits who need visas, they may apply to Ottawa to renew that visa, which is very helpful and should assist in avoiding the type of situation I just described. Next slide. So there's a list of countries whose nationals do not require a visa. Mostly Western European countries, the U.S., Australia, New Zealand, Japan, Singapore, and South Korea. In terms of work permits themselves, they're only going to be issued to foreign nationals. Work is legally defined in the Immigration Act as an activity for which wages are paid or commission is earned, or that is in direct competition with the activities of Canadian citizens or permanent residents. And the reason that is significant is that we've seen employers send persons to Canada arguing that they don't need a work permit because they're being paid outside of Canada by their company, and they're just simply here as a representative of their company. But the reality is, excuse me, that if they're in direct competition with the activities of Canadian citizens or permanent residents, it doesn't matter who's paying them or where they're being paid. They are considered to be working. And work permits are written authorizations either issued by a diplomatic post or now more likely a letter issued by a diplomatic post that advises the bearer to present the letter to an officer at the port of entry for issuance of the permit. And from within Canada, you may file for extensions of these permits. And that is an obligation that your employees should be well aware of, because the onus is on them to ensure that they get extensions of their particular permits. And although extensions are filed through Case Processing Center Bakerville, the key point to remember, if we go to the next slide, I'm just going to leave that for a moment, is this issue of implied status. So as long as your employee files for an extension of their current work permit before it expires, either physically by courier or never mail an application to Case Processing Center Bakerville. Either because if it goes missing, unless you can show it was delivered, they're just going to say, well, we never received it, and that's going to cause you a lot of grief. But as long as that application for extension reaches Case Processing Center Bakerville before the expiry date on the face of the document, the worker has implied status to continue working. Even though the document's expired, they can continue working. However, don't leave the country. Leave the country, your status is extinguished, as your implied status is extinguished. So that's very important to remember. Next status, please, or slide, please. All right, are there any questions before I move on to part 2, which is the labor market impact assessment? Okay. All right, we're going to move on to part 2. All right, in terms of terminology, the LMIA is just a new name for an old concept formerly referred to as the labor market opinion. But the process was revamped significantly in July 2014, as I've alluded to. In most cases, an LMA will be required unless there's an exemption from the LMIA process. And no work permit will be issued until the Canadian employer has obtained labor certification for the temporary foreign worker by way of an LMIA. And there are a litany of exceptions in immigration regulations for persons who do not require the LMIA prior to obtaining a work permit. So, and probably one of the most common ones is spouse of a temporary foreign worker in Canada is eligible for what's called an open work permit, and it is LMIA exempt. And an open work permit, just to be clear, an open work permit is a work permit that doesn't identify a specific employer. And if it does not identify a specific employer, then that person can work from whoever they please as long as the work permit is valid. If it does identify a specific employer, then if someone goes and works for another company that is not directly mentioned on that work permit, they're in violation of their terms and conditions of admission. Now, general terms, and this is me editorializing, but it is an obstructive process. And so try and look for an LMIA exempt category if you possibly can. But please do not ignore the LMIA process and simply bring in the worker. I'll give you an example. We had a client, international engineering firm with a large contract, work in British Columbia, multi-million-dollar contract. They needed to send one of their chief engineers to British Columbia immediately. And of course, immigration doesn't really understand the concept of immediacy or urgency. And they sent that person into Canada and had him on site without any valid work permit. Then they phoned us. So what we had to do was pull him out, send him out of the country, apply for the LMIA, which took 30 days of advertising, which will come to the advertising concept in a while, but so 30 days of advertising, and then because he was considered a high wage earner in the province of British Columbia, we got it turned around in 10 days. But it could cause significant problems for employers and the employees when that type of activity is conducted. So, for example, working without authorization is what's called a non-compliance violation. Once the unlawful worker leaves Canada, the violation ceases. An officer may bar issuance of a work permit for 6 months on re-entry. So there are severe consequences for working without authorization. An individual is subject to removal by exclusion order, which means they're unable to return to Canada for 1 year. And if it's established there's an allegation of misrepresentation, and that's pretty easy because if you come in at the border and you say you're not working, but you are actually going up to a site, that is a material misrepresentation. And if you establish a material misrepresentation, a 2-year ban will be imposed on that worker. Next slide, please. There are several types of removal orders. Exclusion, which is a 1 or 2 year bar. Deportation, which is a permanent bar, just by way of information that departure orders will be issued to permanent residents who lose their status. Departure orders are a slap on the wrist. You just leave. There's no bar on re-entry. But exclusion orders and deportation orders do affect your ability to get back into Canada. And note this slide, work violations result in the exclusion order, but the failure to obtain permission to return to Canada while under exclusion will result in a permanent bar through removal order. Well, it's going to be through a deportation order. And the only way you get back into Canada, if you've been deported, is if you have the minister's consent. And that is not easy to obtain. Next slide, please. Sanctions against employers. Immigration and Refugee Protection Act, Section 124. The unauthorized employment of foreign nationals. There's a maximum of a $50,000 fine and a term of imprisonment for a term not more than 2 years or both. And in the legislation, it does state, I quote, an employer who fails to exercise due diligence to determine whether employment is authorized under this act is deemed to know that it is not authorized. So it's not good enough to tell immigration authorities, well, he told me he had a work permit. We've seen that as well. You better see that work permit. You better see that it's valid. Don't just ask for a temporary social insurance number. You know the difference between a temporary and a permanent number. A temporary number has a 900 series. It commences with 900 series. And in British Columbia, SIN numbers commence with a 700, permanent SIN numbers commence with a 700 series. So you have to be cognizant of your obligations as employers when you're dealing with foreign workers. Slide, please. All right, the LMIA process. It's a three-step process to hire a foreign national. The employer applies to Employment and Social Development Canada, ESDC, which is just another name for Service Canada, for validation of the offer of employment. If the offer of employment is validated, the LMIA is going to be issued. And once the foreign worker has the LMIA in their possession, they will apply for a work permit. Now, if they need a visa, they will be applying overseas. If they do not need a visa, they do not come from a country where there is a concern about health requirements, which makes them obtain a medical, they can apply at the port of entry. But if they're going to apply at the port of entry with their document, make sure that the application for the work permit is complete, that the LMIA is attached so that they can submit it when they arrive either at the land crossing or at Vancouver Airport. Next. Now, I'm going to refer to requirements that existed in the age of the LMO that still apply. The job offer must be genuine and have a neutral or positive effect on the labor market. Specifically, a job offer will have a neutral or positive effect if it can be established that jobs are created for Canadians, skills and knowledge are transferred, a labor shortage is alleviated, the wage offered is consistent with the prevailing wage rate for the occupation, and the employer made reasonable efforts to hire or train Canadians or permanent residents. Now, so just go to the next slide, Matt. Murray River decision from February 2013 is a very significant decision because, in general terms, when employers apply for LMIAs and they're denied for a litany of reasons, and we'll come to that as well, it's a very expensive process for an employer to seek judicial review of that particular negative decision. And it's rarely done, which gives Service Canada a lot of license in terms of denying applications. But in the Murray River decision, which was actually a fight between a union and an employer over the importation of a group of miners from Asia for a project in northern British Columbia, the matter did go to court. And if you just go back for a moment, one of the issues was these legislated items concerning what constitutes a neutral or positive effect. Now, if you'll go back. So the Honorable Mr. Justice Zinn held it is not necessary that an applicant meet every one of those factors that was listed on the previous slide. The decision maker must examine and assess each factor and then perform a weighing exercise to decide whether the LMO will issue. With respect to the accuracy of recruitment efforts, an employer must be given some latitude in its hiring, even within the temporary foreign worker program. Well, in our experience, regardless of this particular decision, there is not a lot of latitude. They are very restrictive in their approach. They're very aggressive in terms of their decisions in rejecting applications because they are fundamentally tied to the Canadians First policy. Okay? And so, go to the next slide. Canadian Reformed Church of Cloverdale went to court. They had the means, and obviously they were not happy with a denial of an LMIA for one of their foreign workers. And in allowing an application for judicial review and ordering another officer to reconsider the assessment made by ESDC, the Honorable Mr. Justice O'Reilly stated, The author did not determine whether the church had actually made reasonable efforts to hire or train a Canadian in accordance with the regulatory standard, but rather rejected the assessment for the solitary reason that the advertisements lacked a business address. This officer appears to have treated the guidelines as mandatory obligations. So, when you go on the Service Canada website and you read all the requirements that they insist upon in terms of advertising, in terms of wage rates, and their other mandatory requirements, the federal court, this decision, has said that they're not mandatory obligations. My advice is you follow those guidelines because they are still very aggressive in terms of the rejection of some of these applications. So, for example, we had a client who applied. As you may or may not know, you have to apply on either the Federal Job Bank or the Work BC site, plus 2 other sites. And in one of the sites, he failed to record the educational qualifications. And this was in the IT industry, in a company that expanded from about 18 to 40 employees in the space of about 1 or 2 years, and was importing a lot of foreign workers because he couldn't find people here. And they rejected because they said, well, you didn't publish on one of the sites the fact that there were educational qualifications involved, even though they were on the other 2 sites. So that's the type of rather small-mindedness that seems to be driven by this overwhelming desire to protect the Canadian labor market. Next slide, please. And as we've alluded to earlier, labor certification was revamped by the federal government in July 2014 and designed to crack down on the use of temporary foreign workers by employers and to emphasize this Canadian first policy. Now, there are noteworthy changes brought by the new LMIA process, which I'll go through in more detail. But those changes in summary are using wages rather than the National Occupations Classification to classify positions. Are you all familiar with the National Occupations Classification and the matrix, which categorizes jobs by management, which is skill level 0, professional skill level A, post-secondary education and for skilled trades is B, and then C and D, which are classifications of jobs that do not require post-secondary education. So they're going to a wage matrix rather than the NOC matrix for this under these new rules. There's a cap on low-wage positions. They will refuse applications in areas of high unemployment, as that is statistically demonstrated. They will reduce the duration of work permits, and there are transition plans required for temporary high-wage workers. So if we go to the next section. And fundamentally, there's their statement of principle right there. The temporary foreign worker program is no longer being used as it was intended to be used, as a last and limited resort to allow employers to bring foreign workers to Canada on a temporary basis to fill jobs for which qualified Canadians are not available. All right. Now, more detail. In overhauling this program, there is a cap to limit the proportion of low-wage temporary foreign workers a business can employ. The cap is designed to restrict access to the temporary foreign worker program. Employers with 10 or more employees are subject to a cap of 10% on the proportion of their workforce consisting of low-wage temporary foreign workers as of July 1st of this year. Cap is applied per work site and is based on total hours worked. Next. An LMIA application will not be processed at all if all the following criteria are in play. The employer is applying to place a foreign worker in an economic region with an annual unemployment rate of over 6%. The employer is seeking an LMIA in accommodation and food service or retail sales. And by the way, the government of British Columbia has reestablished under its provincial nomination program a pilot project in the food service industry, because on one hand, you've got the federal government saying they're not going to let you get an LMIA in the food service industry. The province is saying we have a project, because the province is saying we have a pilot project and we will accommodate people in the food service industry because the province sees a demand in that sector. Will not be able to get an LMIA for light-duty cleaners, cashiers, construction laborers, and janitors, to name a few, on a list that is on the Service Canada website. Next. So what's the low-wage category? If the prevailing wage, that is the statistical median wage, is below a specific hourly rate as calculated by each province, it is low wage. In British Columbia, the median wage up until the 29th of April 2016 was $22 an hour. It is now $22.60. So everything over $22.60 an hour is considered a high wage category. So we've got, in terms of primary categories, we have the low wage category, we have the high wage category. We have the primary agricultural stream, which is for general farm workers, harvesting laborers, nursery and greenhouse workers. One of the benefits or at least under this primary agricultural stream, is that you only have to advertise for 14 days. And normally it's 30. So I guess, looking at their demographics, have determined that in the agricultural stream, they've got to relax their advertising requirements. Live-in caregivers remains unchanged as a category. Next slide, please. Highest demand workers are there's a list of in-demand skilled trades, which you have to look at to see whether your foreign national is within that particular category. Highest paid workers, the top 10% of wage earners by province. In British Columbia, the top wage amount as of April 30th, 2016 is $41.63 per hour, which is basically about $81,000 a year. It is subject to change. In fact, I do mention this further on in our slide, but you got to look at the Service Canada site every time you go to do this. You have to do that because you have to see whether they've updated their forms, because they're not above sending back your entire application if you've used an outdated form, even though the information is all there, but the format has changed, they'll send it back. So it's important every time you file for an LMIA that you look at the Service Canada site, that you make sure that none of the rules that I'm referring to have undergone a change, because they do and they will. All right. Another primary category is for short duration workers of 120 days of employment or less. And for 5, 6, and 7 of the slides, there is a fast-track 10-day processing time. Although I will say I've had them call us and tell us that they can't do it in 10 days for whatever reason, okay? But effectively, if you're hiring skilled professionals or skilled trades at over $81,000 a year right now, theoretically, after you've finished your period of advertising and you file, you should be able to get a response within 10 days. Otherwise, you could find yourself with processing times that take at least 3 months. And it may be 8 to 10 weeks after filing the LMIA before ESD calls the employer. Look, you can't, we put this in here in terms of trying to contrast the difference between the highest wage earners getting a 10-day turnaround and workers under that threshold. But honestly, these processing times are always subject to the volume of applications that the Foreign Worker Recruitment Unit is dealing with, and the number of officers that are available. So they're guidelines only. Slide, please. Additional changes to the LMIA process. The information provided by employers now must include the actual number of Canadians that applied for the job, the number of Canadians that were interviewed, and crucially, why a Canadian was not hired for a job. You can pretty well guarantee that or at least you have to assume that you're going to get a call from Service Canada about your application. If you don't, great. If they give it to you, great. But we listen to employers call us up and say that we've got a call from Service Canada, we put this aside, we hadn't really focused on the foreign worker coming in, and I was at a loss to explain the situation to the Service Canada officer, which isn't going to help. So when you file that application, you assume that Service Canada is going to call, and you may be asked to justify your advertising, your wages, and why you didn't select a particular Canadian or permanent resident for a position. Duration of low-wage workers, so in British Columbia, under $22 an hour, their work permits are limited to 1 year. High-wage workers, 2-year permits. For these high-wage positions, most employers need to provide a transition plan. Employers are instructed that they have to invest in skills training to provide for employment opportunities for Canadians, unless the employer will support a permanent resident application. So support the permanent resident application, because if you look on the application form for the LMIA, it's a 14-page document, and it goes into significant detail about your skills training and your transfer of knowledge to the Canadian and permanent resident workforce. Minimum advertising requirements. A minimum of 4 weeks advertising that must continue up to the point of approval of the LMIA. All right? So it used to be that you advertise for 30 days, and we always told individual employers, keep all the resumes in case you are contacted. But now, you can file after 30 days, but the ads have to keep running, right up to the point where the LMIA is issued. The place that you advertise is either the Government of Canada's Job Bank or the provincial equivalent, which is Work British Columbia, and at least 2 or more recruitment sites consistent with normal practice for your occupation. We recommend advertising nationally on at least 2 sites, such as Monster.ca or Workopolis. Advertisements must include the company name, address, title of position, job duties, location, terms of employment, education, and work experience requirements. Remember what I said about our client who he failed to put in the education requirements? He got rejected. And most importantly, minimum wages for the position. Failure to include all elements of the advertising requirements may lead to rejection, notwithstanding what the federal court ruled in the Canadian Reformed Church case that we discussed. They don't seem to appreciate that the law says that you advertise reasonably. And if you omit a business address or you omit the education requirements, that they should be entitled to reject your application. So as I mentioned earlier, advertising requirements may vary by profession. So for on-farm primary agricultural workers, advertising is 14 days. At the moment, or at least at the time I wrote this particular slide, there was no advertising requirements for digital media occupations in British Columbia and Ontario, which include software engineers or graphic designers. But you've got to check. You've got to check the site. Make sure that there aren't any changes to the advertising requirements by occupation. That's why I say check Service Canada guidelines every time you apply. Fees. So for labor certification between 1973 and 2013, there was no charge. Between April 2013 and July 2014, it was $275. Now the fee is $1,000, and there's no refund. If it's refused and you have to apply again, you're going to pay another $1,000. Okay, so I'm also going to just speak about certain changes in the immigration regulations which affect the way you operate as employers and HR managers. As of 2011, under this particular regulation, which is 200 and sub 3 sub G, no work permit will be issued if a foreign national has worked in Canada for one or more periods totaling 4 years, unless a period of 48 months has elapsed since the day on which the foreign national accumulated 4 years of work. The foreign national intends to perform work that would create or maintain significant social, cultural, or economic benefits or opportunities for citizens or permanent residents, or the foreign national intends to perform work pursuant to an international agreement. So, as I've said there, such as NAFTA. And that is a specific example of a way around the 4-year cap on work permits. In particular, under the North American Free Trade Agreement, if you are an international company and you have a parent or subsidiary or affiliate entity in another country, you can transfer executives and senior managers and persons with specialized knowledge from one foreign entity to Canada, and the cap is 7 years. You can keep an executive here for 7 years. You can keep a specialized worker, a knowledge worker here for 5 years. But if truth be told, even though you have an expanded length of time to keep a temporary foreign worker, the smart thing to do is to have them apply for permanent residence such that they will be beyond the requirement of dealing with Service Canada, dealing with immigration, and they will have the same rights and privileges as a Canadian citizen as a permanent resident, except they cannot vote in a federal election, they cannot carry a Canadian passport. But you do have, under agreements such as NAFTA, a period that to keep these temporary foreign workers longer than you normally would, and the normal rule is after 4 years, you're done. Next. 2031E, imposed on the employer at the request of the Immigration Department or a Service Canada officer an obligation to demonstrate that in the 6-year period before seeking the LMIA, the employer provided all foreign workers in its employ in the same occupation as set out in the foreign nationals' offer of employment with wages and working conditions that were substantially the same as, but not less favorable than, those set out in the offer of employment unless the failure was justified. Okay? So you can't effectively distinguish foreign nationals in the same occupation by assigning different wages and working conditions to them, unless it's justified. How can it be justified? A failure is justified if it results from a change in the federal or provincial laws, a change to the provisions of collective agreement. What they say is the implementation of measures by the employer in response to a dramatic change in economic conditions that affect the business of the employer. To go to the next slide, please. An error in interpretation made in good faith by the employer with respect to its obligation. An unintentional accounting or administrative error made by the employer. So, by way of example, looking at subparagraph E here, a client of ours applied for 2.5 years ago. They applied for an LMIA for a worker who was approved, came in, and during the course of the 2.5 years, they changed his job description and they increased his wages. And so when they went to renew the LMIA, they got a call from Service Canada saying, why didn't you inform us of these changes? Look at the obligations on the back of the LMIA application. It says specifically there's a litany of obligations that the employer is to comply with, and that includes informing Service Canada of a change of occupation, a change in wages to the particular individual under the offer of employment. So they suspended the application and they did an investigation. And fortunately, we relied on this administrative error because, in good faith, HR at this particular company didn't really read the fine print on the LMIA approval document. And they were excused and we were able to get it around. Right? So you have to be very careful when you're renewing LMIAs because they're going to take a long, hard look at the old LMIAs to see how you complied with your the employment opportunity you gave that foreign national 2.5 years ago, which is another reason why when you get foreign workers in, if they're eligible for permanent residence, turn them into permanent residence or encourage them to go for permanent residence so they don't have, or you don't have to deal with this type of situation and more than on one occasion. All right, if we go to the next slide, please. Now, if an officer determines that an employer did not provide the same occupation or wages and working conditions to a new employee, Service Canada will notify the employer and can add the employer's name to a blacklist. And the effect is to ban foreign worker hiring for 2 years from the date of determination. Well, since December 2015, there's more than just a 2-year ban. And I'm just going to have to refer to my notes because I want to make this very, very clear. Okay, so the additional penalties that are new refer to violations taking place after December 2015. Okay, and what will happen is that a violation after December 1st, 2015 can involve warnings. It can involve monetary penalties between $500 to $100,000 per violation, up to a maximum of $1 million over 1 year per employer, a ban of 1, 2, 5, or 10 years, or a permanent ban, publication of the employer's identity, and revocation of any LMIA that has been issued or is in process. So, as of December 2015, 5 months ago, they upped the ante in terms of penalties for employers who do not comply with substantially the same regulation that was initially put in place in April 2011. Next slide, please. So, there are methods to employer compliance. Inspection, employer compliance review, which is part of the LMIA application, particularly if you've done it before. They can come in and question you about your hiring practices, and or a review under ministerial instructions. When ESBC or Service Canada receives new information that may justify revocation for policy reasons. So I have included in Appendix 1 of this material that you have before you, the website outline of how and when they will implement any one of these particular methods of review of your application. So read it. As I mentioned, we've only had one matter come up for suspension inspection, which was the one I raised to you where they didn't disclose that they changed the applicant's job and change his salary. But it's out there, and you have to watch what is going on with types of LMIA applications and the consequences. All right, so if we go to the next slide. Is LMIA the only option? Well, no. LMIA exempt work permits now demand, since the end of October, a $230 fee in advance of seeking the LMIA exempt work permit. And when they first put in the LMIA exempt fee for the employer, well, let me just go back a bit. Work permits are $155 a piece. Employers pay $1,000 for an LMIA. But employers using an LMIA exempt process like NAFTA, bringing in a U.S. engineer under NAFTA as an example, there was no fee. And so in October, at the end of October, $230 fee was charged. And you have to pay this fee in advance of your worker going to the port of entry or applying at the visa office for his visa and or work permit. If you do not, they will not accept the application. And now, initially when they brought this in, there was a simple form that the employer filled out and filed with the application. But now it has to be done by an employer portal. Instructions for the employer portal are on the site, and I've been told by several employers how difficult it is to make this employer portal work. But you have to do it, you have to pay the fee. When the application is filed for the work permit, you have to have that confirmation number that the fee has been paid on the application for the work permit. Can we just go back to one more? So alternatives to the LMIA process which lead to work permit issuance are the North American Free Trade Agreement, the General Agreement on Trade and Service, Immigration Regulation 205, and not only CETA, but other free trade agreements that we have with other countries. Okay, so how are we doing for time?
It's currently 9:06, so we're good on time.
Okay. Yeah. Okay, so any questions before I move on? Yes, okay, ma'am.
What if you're making an annual salary adjustment of a standard cost of living across the board for all employees, but specifically someone on an LMIA?
Okay, can you just repeat that question so our online people can hear that?
Sure.
Sorry. All right.
So my question is, what if you're making an annual adjustment, a cost of living, say 3%? You're doing that specifically for the person on an LMIA, but also across the board for all employees.
Yeah.
Is that a concern with respect to a significant change or keeping the wages substantially the same?
Well, it says substantially the same. To be safe, I would just advise them. If you've got someone, just advise the LMIA. If you go to your LMIA, the approval document, you look on that back page, and it sets out all the obligations that you as the employer take. I would say that it's broad enough that you should advise them. I know it's a simple matter, but just to be on the safe side, I mean, you've got a good argument. It's substantially the same. It's what, a 3% raise,
And it's across the board.
And it's across the board.
More or less.
Yeah, but you don't want Service Canada phoning you up when you go to renew that LMIA and say, well, wait a minute, now when you issue this offer of employment, it was at this wage doing this occupation. So I would, to be on the safe side, I just drop them a line, one liner, okay? Just, but I'm a lawyer. I'm thinking things the worst case scenario. But then again, we've talked to Service Canada a lot, and as you may have guessed, I'm not terribly impressed with some of the way they operate. And that's why we, as a firm, when employers approach us, the first thing we do is see if there is a lawful way around an LMIA process. And there are, and we're going to discuss some of those now in terms of these agreements.
Thank you.
Okay? Okay, so, all right, I'm going to go on. So we'll start with the North American Free Trade Agreement. Established January 1st, 1994, United States, Mexico, and Canada.
abolish tariffs and other trade barriers. And it's interesting to note that notwithstanding that we have this agreement since 1994, that in 2009, the Government of Canada, for good reason, slapped a visa restriction on Mexican nationals. And the reason was an influx of economic migrants making refugee claims at our ports of entry. And it got to a point where they couldn't handle the volumes. And the most immediate method of dealing with it was to slap the visa restriction on Mexican nationals. In terms of slapping visa restrictions on countries, they do it overnight. There's no advance warning. You go to work on a Tuesday, and on Wednesday, it's there all of a sudden, because they're not going to allow a rush of applications either at a port of entry or at a visa office. So when they make these changes, they make them very quickly. But notwithstanding that we have this free trade agreement until further notice, Mexican nationals still need a visa, but I do expect that is going to be relieved in the next month or two. So NAFTA does deal with abolishing of tariffs and abolishing other trade barriers. It also has Chapter 16. Chapter 16 deals with the temporary entry of selected business persons. The categories of business persons that are LMIA exempt are business visitors, professionals, intercompany transferees, and traders and investors. The top three you will deal with. The traders and investors, highly unlikely. Next. These are permissible NAFTA business activities: consultation, business meetings, contract negotiation, sales negotiation, research, participation in educational activities, business conventions or seminars. Okay? Right. International business activities related to research and design, growth, manufacturing and production, marketing, sales and distribution, after-sales service, and general service. But I will say that although no work permit is required for business visitors, you have to be familiar with the NAFTA Chapter 16 as it applies to this these particular categories of business visitors, because when you get into after-sales service agreements and you're bringing up someone to install equipment for you on a purchase of, say, you buy something from Boeing and you have it sent up to Vancouver to be installed, you've got to understand exactly what the limitations are on importing after-sales service personnel. As long as you meet the criteria in NAFTA for after-sales service personnel, they'll be able to come up, normally just with a letter from the company indicating what they're doing and why it complies with that, and they'll just come in and be able to perform that service. But many a time we've had people stopped because it's not clear that it meets the criteria. And generally speaking, there has to be a contract, a contract in place, either subsequent to the or inclusive in this sale agreement that allows for after-sales service. All right, so no work permit for business visitors in these particular situations. Okay. I'm just going to say one other thing about business visitors before we go into NAFTA professional, and that is that fundamentally, an international business activity that does not require a work permit if the worker is paid outside of Canada and the profits from their activities revert, the majority of those profits revert outside of Canada. So that's why you see many American salesmen coming in here. They're paid by their American company. They're allowed to make sales. Those the profits from those sales leave the country. There's nothing wrong with that, as long as they're selling American products. Where we've seen problems is when they come in and try, they are sales personnel, they are paid outside of Canada, but they try and sell Canadian-based products, and that doesn't meet the strict criteria under NAFTA. NAFTA professionals,
provide prearranged professional services as salaried employees or by contract between the person and the Canadian employer or the person's company and the Canadian-based employer. There are 63 professional occupations, and you must be performing services in Canada in your profession. So if you're an engineer and you are working for a Seattle-based engineering firm and you're coming up to work on a Calgary-based project, then you can't be coming up as a management consultant. You have to come up and work in your capacity as an engineer. After professionals do require a work permit, and the best part of this category is you professionals may receive a work permit for up to 3 years at the discretion of an immigration officer, and you can renew them. And there's no cap on it. So I would say if you are hiring from the United States, and it is a professional occupation, look at NAFTA, because realistically, this is all that has to happen. If you, rather than wading through the LMIA process, you, for example, have an engineer or an accountant or one of the other 60 occupations on the list that you're bringing in from the United States. If you can show that they're an American citizen, if you can show that they have a contract of employment, and they're coming up here for a limited period of time, then they can apply at the port of entry and they will receive a work permit. And you will have to pay that employer compliance fee, $230 in advance, but it's a relatively very simple process to get into Canada as a NAFTA professional. Okay, NAFTA intercompany transferees is something that we deal with quite a bit. So, the ground rules are foreign nationals employed by U.S. or Mexican enterprises as a manager or executive, or who possess specialized knowledge to be transferred to a parent, branch, subsidiary, or affiliate to provide services in a similar capacity. But, the big but, employed at least one of the past 3 years by the foreign entity. You cannot hire someone in, for example, your at IBM San Francisco and immediately flip him up to IBM Vancouver. You're not going to get away with that because you are clearly circumventing the LMIA process. They want you to hire or to transfer someone with at least 1 year in the past 3 years with your firm. Okay? Intercompany transferees are exempt from the LMIA process. They do require a work permit. Validity periods vary. It can be engagement specific, or it can range from up to 1 to 3 years. The maximum validity period, as I mentioned before, is 7 years for executives and managers. And when we say managers, we mean senior managers. They will object to what they call middle managers under the NOC matrix. So 7 years for executives and senior managers, and 5 years for specialized knowledge workers. It's open for new companies to transfer an executive manager or person with specialized knowledge. So you can send a point person in to open up a new office. So for example, in the fall, we had a European company who had worked in Africa and had decided that they wanted to expand to North America. And so they were going to put a person into the port of New Orleans, and they were going to put a person into the port of Vancouver. So they created a company here. We made an application for him to come in. We demonstrated that he was a long-term employee, that they had entered into negotiations to obtain lease space, physical premises. You don't have to do that, but within a year you should do that. And he's come over from Europe to open up their operation, and their operation is designed to assist traders in port with the supply of services and before they leave port. So it can be done. Okay. General Agreement on Trade and Services permits temporary entry of business persons in 3 categories: business visitors, intercompany transferees, and professionals. Business visitors and intercompany transferees entering under this agreement qualify under the General Immigration Regulations pursuant to our Immigration and Refugee Protection Act. However, the professional category, which I told you how good the professional category is for you as an employer, bringing in persons under NAFTA in that category. But under GATT, it's limited to 9 occupations and 90 days of entry within 12 months. So you would only use this, for example, if you had a UK engineer that you needed on an immediate basis, and he worked for your overseas office, and you wanted to transfer him to Canada. On that, you could get him here for up to 90 days if it's urgent, and then you're going to have to find another category to extend his ability to remain in Canada and work on a work permit. Okay? Use an engineer as an example. As you can see there is a list. Okay, Immigration Regulation 205. It permits the entry of foreign workers on LMIA exempt work permits if the work would create or maintain significant social, cultural, or economic benefits or opportunities for Canadian residents. Those are typical examples. It's very broadly drafted, so there is a lot of room to apply under this particular category, but immigration takes a very restrictive approach to certain aspects under Regulation 205. Not so much with intercompany transferees, because as I said, you can get an intercompany transferee in under the North American Free Trade Agreement, but you can also, so that applies to Americans and Mexican nationals, but you can also get intercompany transferees in from your operations in Asia or in Europe on the same basis. If there's a corporate relationship and the person's an executive or manager, and you are transferring, or a person with specialized knowledge, and you're transferring them across, you can use that intercompany transferee rule. But self-employed workers, that wouldn't normally apply to you, but we have had to deal with those on occasion, and immigration takes a long, hard look at those type of applications. Okay, CETA, September 26, 2014. Canada-European Free Trade Agreement is signed by Canada. It's not yet implemented. DJ is going to speak about this in more detail. Prime Minister announced on February 19th that the likelihood of implementation is very promising. It does, from an immigration perspective, which is important obviously to me, that it provides for labor mobility amongst the signatories. It will permit the entry of what they consider to be key personnel from European signatories. Key personnel will include managers, investors, what they call intercorporate transfers, and independent professionals who are self-employed. All right? But that alone is subject of another because it's going to change the way your companies deal with European workers. We can go on. We do have free trade agreements with these countries: Chile, Peru, Colombia, and Korea. And I would encourage you to look at the labor mobility provisions of those agreements if you are contemplating hiring nationals from those countries that may apply to your particular situation and save you from having to address an LMIA issue. Okay, so I think I'm going to defer to Didier. How much time do we have?
You're currently at 9:23.
Okay. Shall we take a break? Do you have time, or do you keep going? Okay. Didier, I'm going to turn the matter over to you. And if there are any questions, if you want to write them down after Didier's finished, if time permits, I'll answer them on the mic. If not, I'll answer them for you personally. All right, thanks.
Thanks, Bruce. So just by way of introduction, my name is Didier Culat. I'm an attorney out of Quebec. I practice in mergers, acquisitions, specializing in transnational type of transactions. I have a particular interest in free trade. Throughout my career, I've had to touch on it, and I have a European background, particularly trade agreement. And so I wanted to share with you, in light of Bruce's discussion, of some things that are coming down so that you can kind of peer over the horizon as to what these opportunities are for your business. And so briefly, as Bruce said, September 26, 2014, the free trade agreement was signed. It was a draft document. And we'll go through what are the next steps in that process. But significantly, the document went through what's called legal scrubbing, which all the lawyers from the European Union and Canada kind of look it over and perfect the text to make sure that it has all the proper language in it to be binding, etc. And that process, yes?
I can't hear you.
Can't hear?
Didier, we'll need to get closer to the mic.
Okay.
That's possible.
So the process finished on February 29th, 2016, and now the treaty is being translated, and we're looking for probably it to be presented to the European Council sometime in June. What the CETA does do is it's what we call a comprehensive free trade agreement. It's not just tariffs that are reduced. It also includes trade in goods, services, investment, government procurement, dispute settlement mechanisms, tariff and non-tariff barriers, intellectual property protection, and sustained development coordination. For Canada, this is significant because of all the free trade agreements that it has concluded since we started the United States in 1987. This is the largest in terms of population and economic development. We're talking population in Europe of 507 million people. So the impact is much greater than, say, when we concluded a free trade agreement with Chile or Honduras. And on the European side, it's also the first time that they're concluding a free trade agreement with a country that's a member of the G7. So for them, it's also a major agreement, a major step forward, and a change in their approach, because up till now, Europeans have been much more oriented towards a peace dividend approach of, we want to bring peace and prosperity to some parts of the third world that are developing world that are of interest. And the other thing, kind of like that's happening at the same time, and Mr. Trump starts building walls everywhere, but there is a negotiation underway with the United States on a free trade agreement of a similar magnitude. It has a bit more opposition in Europe. It has some issues on the state level in the United States, which makes it a bit more complex to get over the finish line. But right now, Canada is 3, maybe 4 years in advance on the United States. Kind of questions out there. If they do reach an agreement with the United States, will they do the same thing they did with NAFTA, where we had a free trade agreement, Canada, United States, and when we put in the one with Mexico, it superseded the first one that was just bilateral. So that's kind of like the general context. It has a section just like the NAFTA, and here we're kind of like projecting what will happen, because it's not implemented, the regulations aren't written, the exemptions aren't written, but what Canada has done, it has followed the principles that were developed over 30 years ago with NAFTA, and so the expectation is that probably 90% of what we're doing with the United States, we will be doing with Europe, and all those mobility exceptions that Bruce spoke to you about under NAFTA will apply under CETA, and so you're going to be able to source European employees easier than you are doing so right now with all those exemptions. But there's a couple things that are you have to keep in mind. First of all, the immigration laws will not disappear. So as much as the Europeans think of the Maastricht Treaty, which gave them mobility throughout Europe without visa and what's called the Schengen zone, that will not happen. There are categories of people that can come, but it's not an open border situation. Visa requirements are not a violation of the agreement, and this is explicitly written in the agreement. Probably came up as a specification that Canada wanted to put in, especially with what had happened with Mexico under NAFTA. And currently, I think there's 2 or 3 countries that require visas to come visit, and the Europeans aren't too pleased about that. But I think Bulgaria, Romania, and one of the Slovakias that have these visa requirements. That will not be considered a violation of the agreement. Will not be a source of a dispute between the European Union and Canada. We think work permits will be required in certain categories of employment. So as you see with NAFTA, a similar type of situation would occur in certain fields. What they have done is they've created 8 categories of business travelers. On the next slide, we'll detail who those are. And there's 11 recognized activities of business. So if you're in Canada and you want to bring someone in, it's easy, you got one set of rules. But if you're a Canadian corporation wanting to send someone to Europe on these rules, well, you've got to really look at it, because there's a series of reservations that each country has put in place. We have to remember, immigration is not a European Union jurisdiction. Immigration is a state by state. So you have 28 states, 28 sets of rules, 8 categories of business travelers, and 11 fields of category. So you kind of like do the math, and we're close to 2,500 types of situations that you need to be addressing specifically. Some of them need an economic needs test, which is the equivalent of the LMIA. And in other situations, there is no regulation. So it's not because immigration is at the state level. It's a much more complex to send someone over there. And this is the next part is something that didn't exist in the free trade agreement with the United States, but it has now exists. We all have these electronic visas where they swipe it and they have a printout. Well, they're going to be exchanging information between Canada and the EU and the EU countries. So they're going to know how long you've been in a jurisdiction. So 2 consequences. One is immigration, where they're going to say, well, you've been here a lot over the years, and maybe you should have a permit. Maybe, why are you coming in so often? And it could complexify a presence in a jurisdiction. The other thing is tax, because all of a sudden they're going to be able to add up and see if you've spent more than 183 days in that jurisdiction, and whether all of a sudden you become a tax resident, as opposed, in lieu of the fact that your domicile is elsewhere. Because all of a sudden you're going to have to be paying taxes in France and in Canada, and have to your employee's taxation situation is going to get much more complicated. So that's something else that you need to be aware. They are going to be able to add up how much time you've been in. I've had situations where I've had a Canadian corporation, Canadian CEO. He has a subsidiary in the United States, and he goes down once a month for 3 or 4 days just to speak to the general manager, meet his staff, settle problems. It's part of his job description to supervise those operations. And so at one point he's at Toronto transiting into the United States, and the U.S. Customs said, well, you come here often. What do you do? Well, he says, I'm a CEO who got a sub, but I'm paid by the Canadian corporation, and I'm only there for 3 or 4 days each time. And he says, well, I'm going to let you in this time, but you're going to need a worker's permit next time. Then types it in. So that the next time you swipe the passport at any U.S. entry, it's going to say, this guy needs a worker's permit. So then we had to hustle to get him a worker's permit under NAFTA. But I mean, there's still some formalities. It's not just, hi, I'm here, I'm the CEO. There's a stack of paper that needed to be prepared in order for him to get his worker's permit. And obviously, all this is done at port of entry. So, your customs, when we did it, we planned a trip for him, and we said, you're going to do this through Montreal, but if you're in, because you're not coming there with a lawyer, you're coming there one-on-one with the immigration officer. You want him to have his package and ready to process. But, in case he was in trouble, we wanted, we were like half an hour away from the airport. We could come and assist him with that. And the last thing, and this is going to be interesting as well, is the mutual recognition of professionals, where you're going to be able to bring in professionals, and they're going to be certified. They can be certified in British Columbia under their professional qualifications, and obviously, perhaps for engineers, architects, those could be something that's particularly important. Next slide. So these are the 8 business traveler categories: investment purposes, investors, intercorporate transferees, senior personnel, graduate trainees, contract service providers, independent professionals. So you see that some of the principles that you had under free trade with the United States are there. Some of the categories under the General Agreements of Trade and Services are there, and then there's some other criteria. All these are defined terms under CETA, and we can expect that, as I say, the stuff already in our regulations under the North American Free Trade Agreement could be augmented to include these categories and include these countries. But our expectation today is that 90% will be an extension of what is already out there by our government. These are the 11 types of commercial, recognized commercial activities. What this means is that for those 8 types of business, temporary business travelers, and through these 11 categories, it's kind of like an express lane acceptance into the jurisdiction. So that's very much of interest, and obviously facilitates the entry of those people on a temporary basis. And I don't, there's nothing really that I think are self-explanatory. But what is important is, and this is more when you're sending someone to Europe. This is where you get in these categories. They have different qualifications and tests depending on the 28 countries of the European Union. So this is really, if you've got someone, and I think we have an article that Bruce and I wrote that's in your post where we kind of explain this. But example, if you're sending someone to Austria for a trade show, part of our business plan, we attend trade shows. Well, there's a certain amount of time that you can spend in Austria under the auspices of the agreement, but if and a certain amount of trade shows that you can go in Austria. Otherwise, you'll need a worker's permit. So these are the types of things that if you're going to use the opportunities that the free trade agreement are going to bring to your business by sending personnel out there to raise awareness of your company and conjure up some business, well, you need to be flipping through to, okay, where are you going? How long are you staying? How many days have you been there in the year? Example, Austria says if you've been at trade shows for more than 30 days in the year, you've got an issue. So I mean, these are the types of things that will need to be checked, and the advice that we're giving is, be a sophisticated business traveler. You don't want to be, spending this type of money to expand into Europe and to be blocked at the door. And with all the exchange of computer information, they will know who you are, and they'll track you down. Next slide. So, as I said, be advised, be sophisticated. Look at this. As I said, entry into Canada, only one set of rules, the ones that we know and Bruce has explained to you. In Europe, 28 sets of rules. Not the same rules from one country to the next. For example, trade show situation in Austria. If it's to the UK, there are no restrictions, but you still need to check. You still need to be advised. And all those types of categories are what we call in treaty language reservations. So check before you travel, and obviously check in advance of traveling, because some of these things take time to process. As we see in the news these past few months, immigration in Europe is a very tricky field. It is highly politicized, and there's a lot of instability about there, because there are a number of issues at play, and the rise of nationalism in certain countries in Europe will make that a little tricky. Key personnel exceptions, and there are 37. Remember how Bruce was talking about gaps? There was like 9 categories of activities. There's 37 recognized activities for independent professionals. So there's a much wider approach, and probably it reflects how things have developed for independent professionals over time. The General Agreement on Trade and Services is a document that dates from 1970s. And now today we see a larger growth of certified professionals. I think, just an example, I don't know how many there are in BC, but in Quebec, there are 54 professions, people that have professional associations with self-regulated and professional qualifications and disciplinary action. So there's a growth of the field of professionals, and that probably reflects how that's moved on. Next slide. This is probably what is the most interesting, is the mutual recognition of professional qualifications. It's also probably what's most tricky on the Canadian side, because professional certifications are provincial jurisdictions. So, as I know as a lawyer, I'm licensed to practice law in the province of Quebec. I could be certified to practice law in the province of British Columbia, but I'd have to do some formalities with the Law Society of British Columbia in that regard. So what we're beyond the principle to which is to ease mutual recognition of professionals from one jurisdiction to the other, we kind of like have a monopoly board of a situation where we don't even have the same set of rules across our 10 jurisdictions, 10 provincial jurisdictions and in 3 territories for professionals. So we're going to have to create something that's more homogeneous than it is currently. Obviously, it's the federal government who's negotiating this, and it's the provincial government that regulate our professions. And right now, the only kind of like indication of a solution that is already implemented, and may not be the solution, but is what Quebec has done with France. And because of historical links, etc., President Sarkozy came to Quebec a few years ago, and there were a number of trade enhancement agreements that were signed within provincial jurisdiction. And one of those was the mutual recognition of professionals. And subsequent to that agreement, a series of agreements were signed between professional orders and their vis-a-vis in France. So let me only speak to you the ones that I know, which is the one for lawyers. So if I want to be a member of the Paris Bar, all I have to do is I have to go to France, pass an exam, which basically is an ethics exam. It's a verbal exam. It's not even written. Apparently, it's not a pleasant experience. But because a friend of mine did it, and well, they're very arrogant. But regardless of that, it's a simplified process. There's no articling for a year. There's no exams for 6 months. You go there, you do the exams, and then you're called to the Paris Bar. Well, that is because the Law Society of Quebec and the Law Society of Paris have made this agreement to facilitate the mutual recognition of professionals. Now, does that mean I'm all of a sudden, I'm qualified to practice, but I'm still bound by the Code of Ethics that I have no clue what the laws of Paris apply to, the taking of securities on assets. So, either I train myself on that, or I take courses, and then ethically I can practice that, because that's what the Code of Ethics says. It says if you don't know what you're doing, don't do it. And so, that's how it's settled up. But this is what Quebec's done. Will it be what's followed? I don't know. It's a process that is working on that level. It's perhaps the best example. But imagine how convoluted that's going to be, where we have, so we just do the math again. We got 28 countries, okay? We have, on our side, we've got 13 jurisdictions, and you have, like, say, let's just use a number, 25 professional orders. So multiply those three factors together, and those are the amount of agreements of professional qualification and mutual recognition of professionals. So that will be complex when it comes into play, but it has the advantage for you people in human resources that you can be recruiting professionals that will be recognized here in British Columbia, coming from another jurisdiction in Europe, of course. So, so here's, right now, Prime Minister Trudeau, in February, as Bruce mentioned, thinks that it's highly promising that the free trade agreement be enforced in early 2017. A logical date for a whole bunch of reasons is January 1. There's a process. So it's got to be translated into the 22 other languages of the EU. We think that's done. It's very it's a closed door. It's all at heads of government and heads of state level. So all this is very confidential, and things are more announced once they're done than how are they going through the various steps. But the indications that I have from my contacts in government that this is done. And the expectation is that this would be submitted to the Council of the European Union in June. Council of the European Union is all the heads of government and heads of state of the European Union who meet, and that would be that would probably be on their agenda for June. There was a long vetting process of the legal documents. There was some limited controversies that were settled, and we think it will be right by then. It then needs to be approved by the European Parliament. Once approved by the European Parliament, probably 90% of the treaty will be immediately provisionally enforced. Unfortunately for us, in terms of mobility rights, it is a state jurisdiction, and so as is the professional qualification. Well, what's going to happen then is that each country will need to approve the treaty, and it will become in force with those countries of the European Union as it is approved. So that could take some time, but the 90% that's EU exclusive jurisdiction, which is like the customs side of it and the standards side of it, and the sanitary control side of it, will come into force as soon as the European Union, the European Parliament approves it. In Canada, it could be approved by the Parliament of Canada, but constitutionally that's not a formal requirement. Certain treaties have just been approved by the Parliament, but that doesn't make it enforced. What does make it enforced is an implementation act. So, and usually these things are like, the one when we did the free trade agreement between Canada and the United States, the law was that thick. So, that's something that we could anticipate as once gone through at least the approval by the European Council of the European Union, probably in the fall, because Parliament will probably stop sitting in about a month and a half time. There will obviously be some implementation acts in each of the Canadian provinces. particularly we're playing in fields of exclusive provincial jurisdictions such as labor. And this is, we're not sure, but and this will be when it goes to the Council of the European Union. The prevailing thinking right now is that this is a mixed jurisdictional agreement, and it both will need approval at the EU level and at the state level, and that's why I explained to you how it would fall into be enforceable. They could be enforceable in Germany, like a month later, and be enforceable in Poland like 6, 8, 12 months later, depending on when it's addressed in the Parliament. So it's an exciting opportunity for people in Canada. It's an exciting opportunity in terms of business development on the European side. It's also an exciting opportunity for the recruitment of well-educated, qualified personnel, because there's a huge bank of people that are out there that could really help us. And as Bruce was saying at the beginning of this, and that's kind of how we loop it all in, is that we're going to be looking at having another 1 million workers that need jobs, that positions that need workers to fill over the next 10 years, and we'll be able to source them among other places, Europe, and bring them in easier into Canada. So I think that's my last slide. So Bruce and I are here available if there's any questions or comments, either on the game situation. Bruce can explain on what's projected with the Europeans.
Okay, ladies and gentlemen, I'm going to close the session because we're coming up on 10 o'clock, which was our deadline. If there are any questions that you want us to answer, we'll stay behind and answer them for you one-on-one. If you want to send them to us via emails, you have our contact information, and we will answer. All right, thank you.
That's correct. Yeah. I'd like to thank you all for attending, and I also would like to thank you on behalf of Crystal, who's our webinar host from Meritas. And the slides and appendices will be sent to you in a follow-up email. And to our webinar attendees, the recording of the webinar will be sent to you by Crystal. Thank you very much.
Thank you.
Thank you.